So Judge Myron H. Thompson is a United States District Court Judge for the Middle District of Alabama. He was nominated to that seat in 1980 by President Jimmy Carter. He served as Chief Judge of the court from 1991 to 1998. Judge Thompson is a graduate of Yale College and Yale Law School. He served as Assistant Attorney General of Alabama from 1972 to 74. He was the first African-American Assistant Attorney General for the state of Alabama, the first African-American bar examiner for the state, and the second African-American federal judge in the state. Judge Thompson was in private practice from 1974 until 1980. Over the course of Judge Thompson's 40-year career, he has presided over many challenging cases, including those involving separation of church and state, employment discrimination based on sexual orientation, voting rights and racial discrimination in the appointment of polling officials, policing practices and the use of deadly force, racial diversity of Alabama's post-secondary education system, redistricting issues in the city of Montgomery, gay and lesbian rights, restrictions on abortion, racial diversity in the ranks of state troopers, and troubled conditions in the Alabama prison system. Throughout his life, Judge Thompson has represented an extraordinary combination of courage and integrity. One of the last generation of children exposed to polio, he was stricken at an early age, bedridden or confined to a wheelchair at first, but fought back, ultimately being able to walk. Judge Thompson has said that the challenges of polio, as well as growing up in the Jim Crow South, going to segregated schools, using segregated water fountains, and being treated as subhuman, has made him who he is today. Please join me in thanking Judge Thompson for speaking with us.
It truly is a pleasure to be with you today. Get a little closer. First of all, where are the teachers from? I've been introduced to you.
We are from 17 different states: California, Washington, Washington, D.C., New York, and a whole variety in between.
Well, good. So you really represent this country, both from where you are and how you look. That's wonderful. Seeing Judge Marks here with her robe on reminded me of what it means to be a judge. Early on in my career, I went, my wife and I had a birthday party for our, I think he was then about 10 years old son. And it was at the YMCA. And we had a bunch of boys over, because that's what he wanted. He wanted to play basketball and everything else. But one of the 10-year-old boys walked up to me and said, "I hear you're a judge." And I said, "Yes." He said, "Are you for real?" And I said, "Yes." Because I wasn't wearing a robe. And he says, "When's your show on television?" Anyway, that's so. Judge Marks coming out in her robe convinces you that she's a real judge. For those kids, I was not a real judge unless I had a show. But it really is a pleasure to have you here today. And I thought I'd divide my remarks in sort of three parts. I understand you're seeing Montgomery, and it's the center of the civil rights movement, and that's what you're here to do, is to visit these historic places and learn these stories. And you're here now in an incredibly historic courtroom. It's called America's Courtroom. So I thought, as I said, I'd divide my remarks into two parts. The first part is going to deal with this courtroom itself. The second part will deal with what happened in this courtroom back in the 50s, 60s, and 70s, in line with what you've been sort of seeing in Montgomery, from everything from the Parks Museum to the EGI Memorial Museum to hopefully the bus station and other things. And then finally, I'm going to bring you up to date and talk about some of the things I did in this courtroom as a judge. But let's first talk about the courtroom itself. This courtroom, which as I said is called America's Courtroom, was built back in the 1930s. It was part of the Roosevelt effort to employ people when they built all these incredible federal buildings. You couldn't build this stuff today. It just costs too much money. It's just such a beautiful structure. I consider it one of the most beautiful courtrooms in the country. Obviously, that's the ceiling is hand painted. When I first got it, and I first came in here, there were fluorescent lights on the ceiling. And And by the way, that washed out the ceiling. You didn't see the ceiling because it was fluorescent light. But that was part of the 1950s and 60s when everything was fluorescent lights. And so one of the first things I did was to put chandeliers back in here and let the lighting shine back up on the ceiling. And I was able to find some I was able to find some students from Auburn, which is about 50 miles east of here, who were painters. And they came in and we found the stenciling stored in the bottom of the courthouse. We were able to repaint the beams and a lot of the ceilings to restore to what it looked like in 1930. And one of the other things, this is sort of almost like a lecture on how architecture reflects history. One of the other things was, if you look at this courtroom, you'll notice that the bench where I sit, it's a hot seat, is a different color from the jury box. And you'll also notice that the bench, the woodwork, is a different color from the witness box. Any of you have any idea why that might be? One of the reasons is that back in the 30s, when this courtroom was built, a certain group of people could not serve on juries. And I'm not talking about black people. Black people actually could legally serve on juries, however, in Alabama they didn't. Is there any other group that you think of? Women. That's right. Not until the 1950s and 60s did women serve on juries. And if you look at some old movies, like one of my favorite ones is about Abraham Lincoln when he was trying cases out west before he became president. You see all these men on the jury. And one of the things you also see about those men on the jury is they're sitting there like this, with their legs spread open, freely. Well, when women started serving on juries, they were conscious of the fact that, in particular back then, they were more justices. And if you go up in New England and look at some of the old courtrooms, they had these courtesy curtains that came about when women started serving on juries. Also, they put in courtesy curtains around the witness box when women could testify without having their testimony vouched by a male. But anyway, you sort of see that history right in this courtroom. And also, this courtroom has another piece of history, and it's really staring you right in the face. Remember, this courtroom was built in 1930. Any of you think, look around you, and think, what bit of history is reflected in this courtroom? What?
The New Deal?
Not the New Deal. Now, are you a part of this group too?
I'm the videographer.
Pardon me?
I'm the videographer.
Oh, you know what it is though, huh? Okay, well, just look around. Yes, I think you got it. The balcony. You and I would have said balcony. If we were back here in 1930s, in 1940s, in 1950s, in 1960s, we would have been relegated to the Jim Crow balcony. That is still a part of this courtroom. When I was first appointed as a judge, I used to say to myself, God, I hate that balcony, because it reminds you of the indignities that people suffered in this area of the country, in all of this country, like Canada. And whenever I'd come in here as a judge, I'd have to sit here and I'd have to look at that balcony and think about how there was a time when people literally were segregated and had to sit in the balcony. And it was just a reminder that was so troubling. And then the more I sat in here, and the longer I sat in here, the more I became convinced that it's part of our history. And I want to be reminded of the balcony. I want to come in here and see that balcony and remember that people were relegated to that. Because when you erase history, you really erase your present as well. Faulkner said, the past is never past. In other words, what he's saying is we live with that past. And so the balcony to me represents that. And I think it's important that this courtroom had what was then a segregated balcony. It takes even more sort of sex and relief, the fact that it has a segregated balcony, when you think of what happened here in the 50s and 60s, how this courtroom, which had a segregated balcony, suddenly became the center of desegregation. When I first became chief judge, and I was sort of doing a lot of work with the courtroom, I wanted to find out, was the balcony actually used for segregation. I know that you have to look at it. I myself had sat in segregated balconies when I was a child. I remember seeing Gone with the Wind from a segregated balcony down in Dothan, Alabama, with my parents. But I still had no real proof other than the fact that Alabama was segregated, this balcony was segregated. So I asked a number of historians. I said, is there some way we can prove that this balcony was actually used for segregation purposes? And you know what the historian said? He said, no. He said, the only thing you could find is that in 1930, 1940, and 1950, there would be newspaper articles if the balcony had not been used for segregation. In other words, that would have been the news. It was so much a part of segregation during that time when I was growing up as a child, that the only news would have been news that it was not. And the fact that there were no newspaper articles otherwise meant it was definitely blacks were being segregated. And actually, if you really study federal installations, whether it was military or courthouses throughout the South, Mississippi, Georgia, they were all segregated for the most part. I only think when some black lawyers started going into local state courts, where did that begin to sort of fall apart during the 50s and 60s. Constable Baker Motley, Thurgood Marshall, to some degree, were able to go into some of these state courts. Now, there was one other thing too. I asked a historian. The judge who sat here back in the 1940s, one historian told me that there is no way that judge would have had any. This is a federal judge, because that was so much a part of the fabric of the society. And he just said, you study that judge, there's absolutely no way that that particular judge would have had. So we have the balcony here, and as I said, when I first came on, it represented what I considered my humiliation of my folks, personal humiliation, and so forth. I remember also when I was doing cases, particularly involving gender discrimination, and or even some trials that I conducted involving women who had been raped. And quite often, for people who have suffered physical abuse, the physical abuse goes away pretty quickly. You heal. It's the mental abuse that you live with for the rest of your life. If you've been raped, the physical abuse will go away, but you'll never forget the rape. And the same thing applies to race discrimination. It's the personal mental humiliation that you suffer for the rest of your life. And some people say, mental distress, mental humiliation. Why is that a big deal? In fact, sometimes that can be more damaging to you than anything somebody does to you physically. Because that lives with you until the day you die. You never quite get over that mental humiliation. And so, the balcony to me is representative of that. And also, in many ways, I see the balcony as metaphorical in the sense that in our society, there are many people who still live in the balcony in our society. Metaphorically, people who are marginalized, people who are not equal before the law. They may not be physically in the balcony, but metaphorically, they're still in that balcony. And I see that balcony as representing them. And that's another reason why I say don't take it down. I think it should be there. I think people like you who come to this courtroom, yes.
Is it so usable for them?
Oh, yes. When my kids were young, they loved to sit down. When they would come to the courthouse, that's the only, they would run to the balcony. As kids, they could look out over everything. Yes, we use it all the time. Definitely. Actually, one of the little stories I tell about the balcony, I know you know about the little girls who were killed in Birmingham, bombed. Well, I was reading the story of one of the little girls, and she, like me, she was about my age, had been relegated to the balcony. And one of the wonderful stories that's told about her is when she was sitting in the balcony in the movie theaters and other places, public facilities like that, she would throw things down that people would love. And people were talking about what kind of personality she had. And I just thought that's a wonderful idea, that she was a renegade even then. She could throw that popcorn down. I'm not sitting up here and letting it. It's just a wonderful story about this young girl. Of course, the sad ending, of course, she's doing it wrong. But it humanized her. It made you really love her as a person, to read about her. And how she was just a little naughty, which made her human, made her wonderful. But this courtroom, has that background history. And it adds to the notion then that this very courtroom became the center of what occurred in the 1950s and 60s, which was the civil rights movement. Where you're sitting right now, Rosa Parks would have sat. Where you're sitting right now, Dr. King would have sat. Where you're sitting right now, Thurgood Marshall would have appeared here. All of them, all those important figures in civil rights would have appeared in this very courtroom. And one of the reasons that happened was because of the judge who presided back in the 50s, 60s, and 70s. And his name was Frank Thompson. He grew up in Alabama, was appointed by President Eisenhower. No one expected him to sort of do what he did. But he literally, sitting from this bench, changed the landscape, the social landscape, the legal landscape of this state, if not the nation. And one of the first cases that he presided over was the Tuskegee case, involving the Tuskegee gerrymandering of blacks in Tuskegee. In fact, I later learned that my own stepfather was a plaintiff in that case, and I did not know it at the time. He was a minister in Tuskegee, and he was very involved in civil rights. And I remember growing up in Tuskegee that when he would talk and other people would get together, I don't know if you know, do many of you know about Tuskegee? It's a college. It's about 40 miles east of here. It's where Booker T. Washington was responsible for founding it. And George Washington Carver worked there, peanuts and so forth. It was well known because of his work, for which, by the way, he never got a patent. Never saw one. But he created all of these incredible products out of peanuts. And Dr. Booker T. Washington, of course, created the school for black people, and it became sort of a formal school in the state of the nation for blacks. And that's where I grew up. And but when I was growing up, one of the things we were to learn was, my parents would always say, what is the most valuable civil right? It is the right to vote. And Tuskegee is interesting in a sense that it had a black hospital. In other words, if you were black and you were in Tuskegee, you weren't put in the basement of the hospital like you were in Montgomery. If you went to the hospital in Montgomery and you were black, you had to be treated in the basement. If you were in Dothan, which is southeast part of the state where my grandfather lived, if you were black and you had to go to the hospital, in fact, I know this because I went to the basement of the hospital to see someone, you had to be put in that basement. But Tuskegee was unique. It had its own black hospital, which is where I was treated for polio for about most of my childhood, but you were never relegated to the basement because it was all black doctors, all black nurses, and of course the patients that were all black, including myself. So this community had all these black professionals, doctors, of course the college, black teachers, professors, and everything else. And also in Tuskegee, there was a VA hospital. So just this incredible combination. Some people called it like the Harlem of the South. You just had all these black professionals. But you could have a degree from Yale and be black. You could have a degree from Harvard and be black. You could be a PhD. You could be someone, in fact, a few days ago going over to Tuskegee, you could be a prominent orthopedic surgeon they're dedicating a monument to if you were black. The one thing you could not do was vote. You could not vote. No matter how well educated, you could not vote. And yet, a white person who could not read and write could vote in Tuskegee. I remember when my mother going to register to vote. It was considered just an incredible experience. And she studied so hard to prepare for passing the, they had exams back then. They would make you take an exam. Well, of course, if you were white and illiterate, you didn't have to take the exam. Now, you say, how could that happen? Well, it ends up that the registrars who made these decisions, their decisions were not appealable to any higher authority. So they could just make these decisions unilaterally. No one could review them. But anyway, some of the questions that were on the exam, aren't you all teachers? Let me see. One of the questions on the exam was, what is the 11th Amendment? What is the 10th Amendment? What is the 9th Amendment? What is the 17th Amendment? You know, and then they would ask you things like, what is the second provision in the 5th Amendment? And then the clincher was, how many, and this is true, I should have brought them in some of the questions on these exams. How many jelly beans are there in the jar? Those were the questions blacks would have to answer in order to register. And so these black people were essentially relegated to the inability to vote. And so they filed a lawsuit, which was called the Lee versus Lightfoot. And they challenged the fact that they had all been gerrymandered out of the city. The city of Tuskegee, which had all these black professionals, was districted in a way that you'd go down one street and you'd pick up a white family. You'd go down the same street, you'd exclude a black family. You'd go down that street a little bit more and you would include a white family. It was that bad. And Tuskegee brought the first lawsuit. And really challenging what they call asserting your political rights to vote. And it was brought in this courtroom. And eventually they won before Judge Johnson. This white guy from North Alabama who challenges the status quo in Alabama. And then there were many other cases that were brought, including the cases involving, we're going to see this as you go around Montgomery, public transportation. Rosa Parks, the bus boycott. It ended up being Browder versus Gale. It ended up being litigated in this very court. Cases challenging the segregated swimming pools. Now you might ask, why could segregated swimming pools fall under the jurisdiction of the court? Well, it ended up many of these swimming pools were served as public facilities. Even though they were private, they were really public. So Judge Johnson ordered the desegregation of everything. All these public facilities. Then, of course, you reached public transportation, not just buses, but interstate buses, not just buses that ran around the city, but interstate buses, trains, and everything else. It all happened here. And eventually, he ordered the desegregation of public schools. So you're sitting in this courtroom, and it's just amazing the breadth and depth of what happened here when it came to reorganizing the structure of this state and indeed this country. And it was all done through law, application of law. The fact that our Constitution said we're all equal, but it was a promise that was never delivered, at least here in Alabama and many other southern states. So that's why this courtroom is just so historic. And I can, well, as I said, some people consider it rather hallowed. And my place such an important role in what our country is about. I think that, you know, in many ways, people have sort of guessed about Judge Johnson and you know, why did he do what he did, and what's the mindset that makes a judge do what he did. I think it was a mindset, and I'm going to describe it in a minute in a little bit more detail, that says that, you know, he just strongly believed in equality. He strongly believed that you judge Dr. King's words a person based on his or her character. And how did that play out? Well, he not only ordered that blacks be treated equally, he ordered that women be treated equally. He was one of the first judges to order that in the prison system, that women should be guards unless you can prove there's a reason not to have them. You know, they can't perform. You just can't say they can't do it just because. He was one of the first judges to order that the Alabama mental health system be revamped. And not merely put people in the mental health system and basically warehouse them. Yeah, that's an interesting case to read. Alabama was literally warehousing thousands and thousands of people. And you would have a hospital. Actually, I was involved in what's called Wyatt litigation. I inherited it, and I did sort of the second half of it myself. But when he got the case, we'd have like 700 people in one shower. People were literally sleeping in feces. Seeing a doctor was not part of your treatment. That's one thing. You were warehoused. You were in these facilities where people were, unless they were lobotomized, which by the way he ultimately did prove that as well, they were just in these corners, hidden away. It was just incredible totally how inhumane the Alabama mental health system was. And he ordered it changed. It's just an incredible story of what one judge can do. The same thing with the prison system. Unfortunately, I can't talk about that very much because that's before me right now. And one of the things I can't do is talk about the cases before me. But Judge Johnson also addressed the Alabama prison system. But I think one of his most historic decisions was the mental health system. And one thing about the mental health system was Alabama was not unique. The way Alabama treated the mentally ill was no different from the way Massachusetts treated the mentally ill. It was no different from the way California treated the mentally ill. It was no different from the way New York City or New York treated the mentally ill. That was a national problem. But it started here. And eventually, as a result of what he did here, it's actually the standards that he articulated in the case called Wyatt are called the Wyatt standards. And you can go to Peru, you can go to Argentina, you can go to England, you can go to Paris, France, you can go to any state in this country, and if you talk about the treatment of the mentally ill, and if it's somebody who knows about the treatment of the mentally ill, indeed you can go to the United Nations. If you mention the word Wyatt standards, they will know what you're talking about. In other words, his development of these Wyatt standards, which talked about the treatment of number one, the mentally ill, that they had a right to be rehabilitated, and number two, the intellectually challenged. Back then we called them the retarded. Actually, the hospital was called retardation. And people who were retarded or mentally challenged had the right to habilitation, not rehabilitation, but habilitation, which meant that obviously if they were intellectually challenged, you were not going to make them better, but you could make them at least deal with society. You could help them, but you did not warehouse them. If you take away someone's freedom, the least you can do is to make sure that they're treated. In fact, that's sort of paraphrasing what Judge Johnson said in one of his opinions. You take away someone's freedom, and then you treat them like they're inhumane. You don't have to be a philosopher. You don't have to have an IQ of 2,000 to realize that would be wrong. And that's in turn this over our Constitution. Well, that started right there. And so all of these cases really were litigated in this very courtroom. You know, some people, when they think about civil rights, they think about black people. Civil rights involves all of us. It involves, all of us have some family member who's mentally ill, some family member who's disabled. That's all the civil rights that started here. Women, sitting in the jury box, being a lawyer. Alabama, before it actually was required to allow women to serve on juries, had a woman on the Court of Appeals. She could be a judge on the Court of Appeals, but she couldn't hear a case in the jury box. Just shows you how insane that was. But anyway, the point I'm trying to make is that all these cases really grew out of the 1960s and the 1950s and Judge Johnson, and how it spread so much to just all different aspects of society, and how our Constitution was made applicable to everyone, no matter what race you are, what religion you are, what sexual orientation you are. It doesn't matter.
what you are, you're entitled to be treated in a humane way, and you're entitled to equality. And that's what this courtroom stands for. And I told you, I said, you know, what kind of judge does that? You know, I was asking, I've often asked myself about Judge Johnson, what kind of judge is that? And I found one sort of main principle that drove what I consider his cases. And that principle is this, and I've tried to live by it myself. Extend these constitutional principles to people who don't look like you. Until you believe that a principle applies to someone who does not look like you, you don't believe in the principle. It's just a self-interest. All you're doing is you say, it's a me, I want to be treated. When you extend that principle to the person next to you, and that person does not look like you, only then do you test the principle, and then do you believe that the principle should be, is, and should be. Until you do that, you don't really believe in the principle. You're just serving your own personal interest. And so that means that, you know, if you believe in freedom of religion, if you only believe in it, and that it applies to you as a Christian, then you don't really believe in the principle. You just believe that Christians should be treated a certain way. Only when you apply it to a Muslim, only when you apply it to someone who's Jewish, only when you apply it to someone who does not believe and adopt your Christian values, do you suddenly believe in the First Amendment's right to freedom of religion. Or, only when you believe that non-discrimination based on race applies to someone who is Muslim, you know, an Arab, or someone who is black, but also applies to someone who's white, who is Asian, someone who does not look like you, only then do you believe in the principle itself. And that was Judge Johnson to me. He was a white male who extended things to black people. He was a white male who thought about the equal treatment of women. He was a white male who thought about, you know, public transportation and the mentally ill. Absolutely brilliant white male. Why would he care about mentally ill people, mentally retarded people? Everybody he ruled for absolutely did not share his physical characteristics. And that, to me, is what makes a great judge. Is your ability to stand outside of yourself and care about people who don't look like you, who don't even think like you, who don't share your values, but you believe in the principle. I disagree with what you're saying, but I will die for your right to say it. That's the real challenge in the First Amendment. And that's the only time that you really suddenly can say, do I believe in our Constitution? Do I believe in what it says?